on FDA regulatory issues for medical device companies. Today's session concludes our 2021 Holland & Hart Healthcare Compliance Bootcamp series, and we thank you for participating in the previous sessions. As with each of our HealthWall webinars, we'll post a recording of today's session along with the presentation on our HealthWall blog within the next day. Once the recording has been posted, we'll send a link to it and the presentation to all attendees. Should you have questions along the way, please enter those into the chat section, which should display on the right side of your monitor. Time permitting, the panelists will address your questions at the end of the presentation, or they'll answer offline as your questions will be captured via WebEx. One quick note, today's presentation is designed to provide general information or pertinent legal topics and is provided for educational purposes only. The information conveyed does not constitute legal or financial advice. So without further ado, I'd like to introduce today's panelists in the order in which they'll be presenting. We're going to begin with Brent Johnson, who is a partner in Holland & Hart's Salt Lake City office. Brent counsels corporations in a variety of industries with matters concerning products liability, false advertising, labeling and warnings, class actions, and regulatory issues involving the Food and Drug Administration, U.S. Department of Agriculture, Alcohol and Tobacco, Tax and Trade Bureau, Federal Trade Commission, and the Consumer Product Safety Commission. He represents clients in litigation matters in both federal and state courts. As it happens, today is Brent's 25th anniversary as a partner at Holland & Hart, and this is how he's chosen to celebrate it. So kudos to you, Brent. Next, we have Lee Gray, who's a partner in Holland & Hart's Denver office. Lee helps manufacturing clients, and particularly medical device, pharmaceutical, and other FDA-regulated companies. He helps them handle a variety of product-related issues, including regulatory compliance, product labeling, facility inspections, product recalls, product liability litigation, class actions, and resolving commercial disputes. Lee represents manufacturers from regulated industries in dealing with governmental agencies, including the FDA, USDA, FTC, and CPSC, as well as defending manufacturers in litigation matters. Ironically, today is also Lee's 21st anniversary at the firm, and he's also happy to celebrate with you. So finally, we have Christy Kimball. Christy's a partner in Holland & Hart's Salt Lake office. Her practice focuses on counseling health and life sciences companies on a spectrum of operational and regulatory issues, including fraud and abuse, HIPAA, state licensure and credentialing, and FDA regulations. Christy serves as outside counsel to several major hospitals, healthcare businesses, medical device companies, and tech companies operating in the healthcare space. Prior to attending law school, Christy worked for Pfizer for more than 13 years, serving in a management role for several of those years. I'm going to now hand it over to Brent to begin the conversation. Thank you again.
Okay, I'm now unmuted. Hello, everyone. It's nice to meet you virtually. His emphasis or focus is on medical device work, and in particular, the FDA, the dreaded FDA inspection. I will be covering how to get ready, how to prepare for the inspection, then I'll turn it over to Lee next. I want to give you a few background facts, although perhaps you know of them, but oops, okay, I'm learning here. There you go. So here we are, preparing for the FDA. I always like to kind of start presentations with quotes that represent sort of the issues in a nutshell, in a layperson's term regarding what we're talking about. And with FDA inspections, here are three quotes I think are particularly apropos. First, if you recall back in the 80s, during the Iran-Contra hearings, Sullivan represented Ollie North, Colonel Oliver North, and he kept objecting during the hearing and making a lot of statements, and was widely ridiculed by the senators who were conducting the hearing. And he responded, "I am not a potted plant," which means I'm here as a lawyer. I'm here to do my work. I'm not going to sit down and shut up. That's something to keep in mind when you're talking about FDA inspections. Then you also have Blanche Dubois from A Streetcar Named Desire. And she always relied on the kindness of strangers. This is obviously not a really good strategy to adhere to. By the same token, there's a tremendous amount of deference and respect that you have to give to FDA when they come for an inspection, but you should not always rely on the kindness of FDA or its inspectors. And then finally, from Proverbs, even a fool, when he holdeth his peace, is counted wise, and he that shutteth his lips is esteemed a man of understanding, which means don't talk too much. That advice is timeless, but it particularly applies here. Oh, I now totally understand the system. All right. Here is just a statute, 21 U.S.C. section 374A, that gives the FDA the authority to inspect your facility or your manufacturer's facility. The key here is that even though technically the rules provide, the regulations provide, that FDA doesn't need to give you advance notice, unless you have a real problem on your hand and FDA knows about it and wants to do something about it. If you're in the US, they'll give you 5 days of notice before they appear. Before they actually show up, they may request that you send them a copy of your quality system manual and your management review procedures to help them get through the investigation or the inspection more quickly. You're not required to provide them with that. But if you don't, it tends to show or hint to them that maybe you have something to hide. All right. This, of all the slides that we'll discuss today, at least mine, this is the key. And I'm going to give you some advice about confidentiality and protecting your trade secrets and making sure that only the appropriate personnel answer questions, because you don't want people answering questions that don't know what the answers are. But this really is critical. And that is that the refusal to permit inspection is going to get you in trouble. It's prohibited. And responsible persons, if they're individuals, can be liable to up to a year in prison and $100,000 in penalties. And corporations can be exposed to $200,000 or more in penalties. So even though we're going to talk about things that should be of great concern to you in terms of confidentiality, trade secrets, and just making sure the inspection runs smoothly and the information that's given is accurate, you have to keep this in your mind at all times, which is if FDA deems that you're refusing to permit inspection, you could be in real trouble. And that changes the dynamic quite a bit. Okay, so delay in inspections. So if you get a notice letter 5 days before saying, hey, we're coming, we're going to do a quality systems inspection, and you say, no, we need more time, that will be deemed and can be deemed a delay in a pre-announced inspection, which can subject you to this kind of issue with denying an inspection. Even during the inspection, let's say you let them come, FDA inspector to have access to areas of the facility, or if you leave them in a conference room and don't documents or people who have knowledge of how the facility operates, or if you even, and this doesn't happen very often, but even if you say, hey, we have procedures here in terms of cleanliness, and you need to be robed, you need to wear a gown, you need to do this, that, and the other. All of that can and sometimes would be viewed as a delay in inspection, which is tantamount to a denial inspection. Also, delay in producing records. I mean, when we're talking about companies that you are involved with, the issue really is all records based. And if you are a medical device company and you are denying FDA investigators records that they need to do their inspection, which is primarily what they're going to look at, then that can also be viewed as a delay, which is tantamount again to a denial. And you don't want that to happen. Now, the consequences of a delay in inspection are the same as a denial of an inspection. And that is that the FDA may deem your products to be adulterated. Adulterated is an interesting word. The FDA likes to continue, they like to use the same language over all of the foods, beverages, medical devices, pharmaceuticals that they regulate. So they use the word adulterated, but in this context, adulterated tends to mean that your product is subject to a performance standard and it doesn't comply with it. There's a violation of good manufacturing practices. Somehow you're manufacturing a banned device. So the deal here is, even though the word is adulterated, the idea is that you can't sell this device because you are presumed not to be complying with FDA regulations. Here, I did a little survey of 2017, and all of this information is available from the FDA online. But to give you an idea of the kind of violations that rise to the level of being 483 observations, which you don't want if you can avoid them, as you can see, most of them are CAP, which is a violation of corrective action plans. Again, the medical device audit or investigation is primarily focused on your record keeping. And corrective action plans have to be in your files. They have to be adhered to. And they basically, you're required to analyze processes, work operations, concessions, quality audit reports, records, service reports, complaints, return products, and any data that you receive regarding potentially non-conforming products. And these need to be documented. And again, when FDA investigators come to take a look at your facility, the biggest violation, if they find one, is likely going to be in the CAPA area, where you're simply not keeping good records of the complaints you receive, the problems that you hear of, and the investigations that you undertake to be compliant and make sure there's not a problem. After that, you have complaint files, somewhat a little bit more specific, process validation, which is you're required as a medical device manufacturer to have procedures for monitoring and controlling processes and validating the process to make sure that your specs are being met. And if they look through your records and they see that you don't have a process to validate that the specifications that you are supposed to be adhering to are met, you can get hit with that. Design validation is exactly that. We're now getting down on the lower end of the scale. But design validation tends to do with establishing and maintaining procedures for validating the design of your device. And then non-conforming products are when your system ends up spitting out products that don't conform to your specs. Have you documented that in your records, and are you investigating it? Have you resolved it? These are the top 483 observations from medical device companies that you need to be aware of. Okay, the most important item here is prior observations. If you've had a 483 inspection before, and you've received an establishment inspection report from FDA, or worse, if you've got a 483 letter with observations, warnings, or if internally you've generated documents that show that you need to take corrective actions for some reason. If you haven't documented, if you can't demonstrate that you've adequately responded to those, you'll be in real trouble. This is, I mean, if FDA is coming for inspected and there are issues, the next time they show up, those issues need to have been resolved, and you can't do it at the last minute. Okay, so what is your goal or your goals when FDA comes to visit? First and foremost, you want to demonstrate that you understand what your legal obligations are, and you are committed to producing safe products. There is a secondary, and I have to be careful with this, but it's important. A secondary consideration is that you protect the company's trade secret and confidential business information. And that's where we get into talking mostly about photographs and other recordings. But if you operate a medical device facility that has confidential information, has trade secrets that you don't want out, you need to be aware that if you allow FDA to take pictures, make recordings, anything they do is subject to a FOIA request, a Freedom of Information Act request. And that may end up disclosing your confidential trade secrets. So you want to protect them. But again, when we go back to slide 8, which I talked about earlier, you want to protect them without ever being accused of denying an FDA inspection. So how do you meet these goals? First, you have a core team in place that understands what their roles and their responsibilities are within the inspection team. Second, you make sure you have your important records collected in place where they're easily accessible, but you don't want to put them in the same room that the FDA investigators or inspectors are, because you don't want them to treat it like a library and just rummage through anything. But you don't want, when they ask for certain documents, you don't want to say, oh, hold on, and then you can't find them. So they need to be easily accessible, but you don't want, again, to create a library for the FDA inspector. You want to be prepared to answer questions, and you want to, and this is important if you want to protect trade secrets, you want to be able to show that you've consistently treated confidentiality as a serious matter. You can't do it on the spot and say, oh, you want to take a picture? No, we won't allow that. That's confidential. You want to show that you have a consistent approach to confidentiality. And then finally, you want to be able to preserve the differences of opinions and objections that may occur during the investigation. You want to be able to speak your piece during the investigation. So in order to do that, our recommendation is that you create an inspection team. This team are the people who are trained, have enough knowledge, and are careful enough in the way that they speak that they can deal directly with the FDA inspector or inspectors when they come. And typically we have an FDA contact, the person who is really the spokesperson to FDA, a note taker, which is critical, and it should not be the same person as the FDA contact, because the note taker has to take very good notes of what transpires during the investigation. And then technical contacts, because we don't expect the FDA contact to have all of the technical information that the FDA inspector may request. So that's kind of what your team should consist of. I'm going to go through this very briefly, but the FDA inspection policy, this is something that you should prepare with your attorneys. And really it explains in a confidential attorney-client form why it is that you have an FDA inspection manual and why it is that you want to restrict in legitimate ways, not illegitimate ways, but legitimate ways, how the inspection takes place. And then you also have an inspection manual, which can be used on the day of inspection. You can show the FDA investigator, here's our inspection manual. Here's how we do things. Here's what we prohibit. Here's how we want this to work. And that's a set of policies. But it's important to have behind it the inspection policy that sort of validates. Again, you won't show this to FDA, but it validates that what you're doing is legitimate and is not intended to hide information. Okay, the inspection policies are fairly obvious to understand. You want to make sure that the inspectors obey and follow your health and safety rules. You want to make sure that to tell the inspector that they always will be accompanied on their inspection, that they're not allowed to just wander off and start talking to whoever they want to and reviewing anything they want to. That the questions will be directed to the FDA contact or other designated personnel so that the answers that are given are correct. And again, and these are very controversial. I get a lot of blowback on this. But if your facilities have areas that are confidential or trade secret, that you will not permit photography or recording equipment to be used. And again, it's controversial, and if FDA says no, if you refuse to let me take pictures or do other types of recordings, I will view this as a denial of an investigation. You don't want that to happen. And so you've got to be flexible and light on your feet. But if you want to protect your confidential information, your trade secret information, you need to have an inspection policy that provides for that. The health and safety rules everybody understands, and it's actually a good thing to have them because otherwise the inspector might think that you're not really serious about health and safety protocols. The designated personnel may respond to questions. And the fact that some of them may not speak English isn't good enough, but what you want to do is you want to demonstrate to FDA that you're interested in giving them the accurate, correct information, complete information, but you want to make sure that you don't outright refuse interviews of employees. The key is to demonstrate to FDA that what you're doing is reasonable, that directing requests to certain individuals is the way to go because they'll get accurate information. Photographic equipment, again, you have to have a policy and you have to be consistent with it. And I'll skip the slides coming up about how you handle visitors. But the key is that you have to be really consistent about photography. If you have a visitors policy, and you should have one, it should say that visitors are not allowed to take cameras or cell phones, whatever it is that could take pictures or video into the facility. And you have to demonstrate that you're doing it not because you're trying to hide something, but because you want to protect valuable, sensitive trade secrets. Because again, pictures, in the end, those pictures could be produced in litigation under a FOIA request. And you don't want that to happen. The visitor policy, which is what you need to have to be able to show FDA, that doesn't apply to them necessarily, but shows that all visitors are required to obey company rules. They're required to remove watches and loose jewelry if that's necessary. They have to put their cell phones or cameras in the locker and other devices. The key here, again, with respect to FDA, is to demonstrate to them that you're very, very serious about protecting your company's trade secrets and confidential information. And it's just not FDA that you're focused on, but it's any visitor to the facility. There should be signs posted around the facility for no photography, particularly in sensitive areas, to demonstrate again to FDA that this is something that you take very seriously. There's also health questionnaires. I don't have COVID on this one, but you obviously want to show FDA that you're a clean facility and that you make sure that people who have any kinds of health issues, whether temporary or not, that those are registered with them so that you're not going to contaminate any of your equipment. And you should have any visitors verify that. I'll skip that slide because I want to get done. So finally, this is my final slide on this, and I'll turn it over to Lee. You can read on the internet all kinds of information about this. You can hire consulting firms to help you prepare for 43 inspections. You can grab the FDA's 106-page manual on quality systems and read it and analyze it. But you have to do this. you have to conduct mock FDA inspections. You can't just think you're prepared. You have to go through the process and in the end know that you're fully prepared because you've vetted it internally. So you want to conduct mock FDA inspections that include everybody, security, receptionists, and your inspection team that you've designated. You want to make sure that your records are easily accessible, but not just a library for FDA. You want to make sure that whoever has to explain the company's inspection policies is prepared to do that under fire from FDA. And you want to develop inspection routes, which is how you take the FDA inspector around and look at your facilities. Again, the key is, in my view, is it's a balancing act. You never want to be viewed as denying or delaying an FDA inspection. By the same token, you want to show FDA that you're serious about confidentiality and trade secrets. You're serious about hygiene and that they need to obey a set of rules that are sensible, reasonable, and supported. And with that, I'll turn it over to Lee.
Thank you very much, Brent. All right, let's see here if I have the ability. Okay, there we go. So what I would like to talk about today would be the what to do during an inspection. Now that you have done everything that Brent has suggested, you practiced and you're prepared, FDA comes knocking, usually with a little bit of notice. Generally, I believe they give medical device companies about a week. They'll call you the week before they plan on coming out. Here is the FDA's written purpose for the inspection of medical device companies, and that is their purpose is to determine compliance with the FDA regulations, to learn about new technologies and commercial practices from the industry itself, learn the best practices is what they're hoping to do, and collect data on what is going on in the industry to establish or revise regulations. But tucked in the middle of this is an important sentence, and that is inspections may also be used to collect evidence to document violations and support regulatory action. That is, this is basically an evidence collecting effort on their part. And so that means that FDA personnel, they should be courteous and professional, but you shouldn't forget that they are there for a purpose. And their job is to be an investigator, and they're looking for evidence of any kind of violation that your product may have with respect to current good manufacturing practices, perhaps product labeling, hygiene, cleaning, things like that. So keep in mind that everything that they see, everything that they read, and everything that they photograph, if they do, is basically evidence, just like evidence that's used in court. Importantly, the information that they receive from the individuals that they're talking to, the interviews that they're doing on site, is also evidence. So just like they have the samples that they're going to take or things like that, they're also going to get documents as well, and they're going to get statements. And those statements are evidence of what the company does, doesn't do, knows, doesn't know, practices, doesn't practice, just like anything else they're going to find. So this is my most important takeaway from my portion, is with respect to what to do during an FDA investigation, you should always be cooperative. All of your witnesses should be completely honest and not try to hide anything, or certainly not try to lie to any FDA investigators. But they need to keep in mind that they should only answer the questions that are being asked, and they shouldn't speculate or guess. If you don't know something, FDA is perfectly fine to hang out for a few minutes or a little while you go get certain information or go look up something that you don't necessarily have right on hand. But they are not only looking for evidence, they're also looking at the transparency and cooperation that you have as a company. You, the company, have, as I'll discuss here in a few minutes, a permanent record essentially with the FDA. And every time that they've been to your facility before this particular time coming up now, they have notes about that and information about that, and they will go back and look at that information and determine how cooperative you've been, how their agents are taken and dealt with. Do you treat them rudely? Do you treat them like the enemy, or do you treat them as a I sometimes refer to it a little bit as like a big brother. Big brother is generally there to look over your shoulder and sometimes give you good guidance. Occasionally, they may slap you around a little bit. Big brothers can be that way. But even though you may get warning letters or some kind of action from the FDA, generally they're there to encourage and help compliance and to be helpful as well. So you should also, at the end of each day, if you could, I think it makes sense to try to have daily updates that go both ways. Both sides should be telling the other, this is what they think happened so far and what they expect to happen going forward. This is good information to know, which can bring you to the next topic, and that is, how long is this going to take? That's typically what I hear from many clients about this. And the answer is totally, it depends. It depends on a lot of different variables and things. But generally speaking, you should expect, no matter what size you are, that the inspection is going to take several days, possibly a week, maybe even longer than a week, but generally a week is a good rule of thumb. But that depends on the different types of inspections. There are multiple types of inspections to be done. Some are just your typical compliance inspections to make sure you're being compliant. Others are some kind of investigation if there's an issue, or if you have a product recall, or if you've previously gotten a 483 letter and they're checking on your responses to that, whether you've done the things that need to be done. Those could be more in depth and take much longer. But a typical, just typical inspection generally will touch on representative sections of what your different SOPs and protocols are, and so we'll talk about that. Your different systems, your quality systems, and things like that. But in looking at all this, they're going to look and definitely note your compliance culture pretty quickly. Basically, once they come in, do things look clean and organized? Do they look messy, disorganized? Are people polite and professional, or are they skeptical and unhelpful? And so these things will find their way into your permanent record, and anybody new coming out to your facility is going to have that background. Even if they're not the same person, they're going to have that background and their own things. We're all human beings, and so they may have some ideas in mind as to what to expect when they come in. And it could be that you are trying to make up some ground from some unhelpful prior inspections. And so I encourage companies to really make sure that they're keeping the emotional quotient, the EQ things in line with how they're treating the inspectors in those instances when you're trying to make up for past mistakes, perhaps. The size of the establishment is also going to matter. If you're, a Johnson & Johnson or somewhere huge that you have just acres of facilities to go through, that's going to affect how much area they can cover and what they're going to want to look at. So the investigations manual that Brent talked about has specific sections, although the specific one he talked about was over 100 pages. The whole thing is over 600 pages and covers all kinds of different situations, all kinds of products, food and beverage, pharmaceutical, medical device. And so these inspectors have a lot of information and training about what they're looking for, and they're going to try to do what's typical in their practice. So the good news is that none of this stuff is secret. You can get access to their investigations manual and directing their staff on how to do this, and you can see what they're looking at. But they don't distinguish between the size of the company. They allow for some discretion based on size, but generally they're looking for the same types of things, regardless of whether you're a very large facility or whether you're pretty small and just have a few people involved in things. The complexity of the product that you're making. If you have a class 3 medical device, you're going to have a little bit more in-depth inspection because there are more controls that are necessary for those type of manufacturers as opposed to a Class 2 or Class 1. All of them are inspected, and the FDA has a right to come into any of your establishments because you give them that right when you register. And then obviously the last and perhaps more important aspect is the complexity, or excuse me, the conditions of what they're actually finding in the establishment. The worse things look, the more they're going to look at. So if you keep things in good working order, you keep things tidy, clean, and it looks like a well-run establishment, then the inspection is probably going to be faster. On the other hand, if it's not, then it's likely going to take longer. So now let's go to the next slide here. Other factors with respect to how long it's going to take is, just as I said before, the firm history. The prior 483s are things that they're looking at. The surveillance inspections, whatever, they're going to be a little bit more detailed and take a little bit longer. So it's good to know why they're there to begin with, to get an idea at the up front of how long it's going to take. And keep in mind with respect to your permanent record, the permanent record is not only notes that the people take during prior inspections, it's the correspondence you've had with the FDA, your MDRs and customer complaints, and product recalls and things like that. So those are the items that they're going to look at to determine, to get an idea of what they think your company is like, which will also direct how long they're going to take. So some of the main considerations to keep in mind during the inspection. Personnel. Your personnel should appear and be professional, trained, knowledgeable. These are the people walking in the halls in addition to the people who are actually talking to the FDA and answering their questions. The facilities should be clean and organized. And so the best thing is to do that all the time instead of trying to, like my kids, clean up their bedroom before you come in for some reason to determine whether they've been keeping it clean or not. Your documentation, you should keep it organized and detailed enough for the size of establishment that you have. So larger establishments need more detailed SOPs because the people aren't seeing each other or talking to each other. If your establishment is pretty small, the FDA is not going to hold it against you that you don't have, a 500-page SOP, standard operating procedures, for everything that you do. You don't need that because your employees have more interaction with each other, and there's not 30 people that are involved with the quality systems or quality management systems that you have. There's a lot of flexibility in what the FDA is looking at when they come on site and do the inspection, but your documentation should be appropriate for the size establishment that you are and how many employees and what you're doing. Often the inspectors are going to use a sampling technique to reduce the time in reviewing documents, and they're going to basically do some statistically based inferences based on what other records look like. And so if they are looking at a few sections of your SOPs and they find them substandard, then they're going to take a deeper dive. They're going to spend maybe another day looking at that, and that's going to lengthen the time of your inspection. And it's also going to cause them to look at more. So because you don't know what sections they're going to pick, you should make sure that all of your documentation is in good order, readily available, and appropriately detailed for the size establishment that you have. They're also going to take, often, not always, product samples. They're going to take product packaging, samples of labels, and things like that, and they're going to look at that to make sure that it complies with both regulatory requirements and with your specifications. Your specifications should cover what those things look like, and if your products don't look like what your written documentation say they should, that's another red flag that can cause some more activity in the inspection. Okay, so the scope of inspection with respect to medical device establishments, generally they're looking at your quality systems, the 21 CFR 820. There's also the 13485, which they are supposed to be merging together to come up with one distinct standard, but for right now it's still Section 820. And they generally group your quality systems into these 7 categories here. And the top ones, I won't say the more important ones, but the ones that they're looking at, the major subsystems are going to be your management controls, your design controls, your production and process controls, and of course CAPA, your corrective and preventative actions. Those are generally going to be reviewed. Some or all of them will be reviewed depending on the type of inspection they're doing. So, and then there are 3 remaining subsystems, which are your facilities and equipment controls, making sure you're cleaning things appropriately, sanitizing the equipment, not just the products, but the equipment. Materials controls is, basically what supplies you have and the process of things becoming the medical devices that you create. Dirty ingredients are going to be a problem, so make sure that your material controls are covering both what other people are doing, your suppliers, and what you are doing with those supplies once you receive them. And then, of course, your document and records and change controls, things that control how you document everything. And all of these cut across the firm's quality management system and are evaluated when they're covering the 4 major subsystems at the top. Now, a level 1 inspection, that's your routine surveillance and initial inspections of all firms, other than the ones that do class 3 devices. And then your level 2 inspections are the initial inspection for the class 3 devices. And those also would include sometimes class 2 devices, depending on the device. And those are also going to include the foreign inspections, and sometimes for training purposes. You don't know it, but if FDA comes to your shop and they're training their own internal people, they may give you a broader inspection just to train their own employees. Now, you could have just a surveillance level 1 inspection where they're looking at certain information and they find some objectionable conditions or problems that they can't adequately address there. Then they can convert it at the district level above them, not the people on the ground, but people above, into a level 2 inspection perhaps. And so, and also there's a level 3, which are the special inspections for cause. And these are follow-up based on the previous 483s or regulatory information they have that suggests a problem they need to be looking into. Those are the ones that are going to last longer. So let's look at some of these quality subsystems quickly. So basically, the management controls, the process of this is just to see if you are providing adequate resources for the activities of the business, the design, manufacturing, quality assurance, the distribution, installation, servicing as necessary. They're also assessing the quality systems as well with respect to monitoring quality and making necessary adjustments as necessary. And then they're also looking into the implementation to see if your quality system has been fully implemented, and if it's monitored and you're basically monitoring it and making changes as you need to. And so another primary purpose of the inspection is to determine whether the management with executive responsibility is ensuring that the quality system is being implemented, established, and implemented. And so each inspection is going to begin and end with a evaluation of the management controls. And they will review, they want to make sure that you're doing reviews and audits to judge how well that process is. Design controls, I won't get into this, is your design history files, what you do to make your product and things like that. They're looking at all of these types of documents, the planning, output, input, review, verification practices, and things like that. And your design history file should have all the documentation of these things. So the more robust that is, the better off you are for this part of the inspection. With respect to the P&PC, the production and process controls, they're looking at what your entity is doing to make the processes they do use to make the products. They're typically going to select a single process to review based on CAPA indications of process problems and higher risk devices, the degree of risk for whatever that process is. They're going to go to the most important parts of the process and look at that. And they're going to look at the variety in your process technologies and the profiles of classes and things like that. So just make sure that you have all of that. I won't get into any more detail of that, but make sure you have that adequately documented. CAPA is obviously a very important system. You need to make sure that you are reviewing, and this is where you have appropriate feedback from your what's going on in the field, your product problems and recalls and things like that come into there, and they're going to review your CAPA system as well. This is also critical in your product liability litigation, if there's any related to your products. They're going to look at the CAPA system to determine whether you should have known about the issue that is relevant to that particular lawsuit before it came up. Inspections are going to look at all of this stuff, and they're going to look at how well you're documenting it and what you're doing with it. And they're also going to check to make sure you're verifying and validating the procedures and everything like that, implementing and recording changes. And the management is appropriately engaged in reviewing those things. And then finally, they're going to look at one of these other systems perhaps. And so they will probably look at them in the context of what they're already looking at. So these aren't going to be things they're specifically focusing on. So the general, here we go. These are your systems, abbreviated, and we've talked about that. The abbreviated are going to be routine surveillance, and they're going to focus mostly on CAPA and production and process controls. The level 2 is more comprehensive, where they look at all 4 of these items that we just discussed. And level 3, the special or the for cause, is going to be a very deep dive into everything that you're doing. Now, the typical procedure is they will start off with their pre-inspection notice and give you a copy of that. And they're going to present their credentials, and then they're going to do a walkthrough to kind of familiarize themselves with the layout of your facility and everything. And then they're going to start the interviews, talking to people to kind of find out where the rubber meets the road, how well these people understand written procedures and what's going on, how articulate they are as far as being able to describe what their job is and what they're doing and what the processes are. And then they're going to do the record review, where they stay in the conference room and review things and ask for copies and things like that. With respect to the interviews, as Brent touched on earlier, your employees should be ready to answer questions. They should not guess. They'll have time to get answers as they need to. I, as a litigator like Brent, treat it as a deposition. You only answer the questions that are asked. You don't volunteer information. If they have a follow-up, they'll ask it. But when they do ask it, provide all the information they're requesting. Ask for clarification if you need it, and then indicate how long it'll take to get answers. We don't have that, but we should be able to get that in a few hours, so you guys can move on with something else, and I'll get this to you when I get a chance. And you can redact financial information or things like that as necessary. And then at the conclusion of the inspection, there will be a management discussion where they talk about things that they've found, potential problems that will show up in a 483, or things that may or may not be reportable. This is kind of your grade of how you're doing. This is a good time for your organization to get great input from FDA and improve their processes. And when they do that, they may take samples, and when they do so at the conclusion of the inspection, they will give you a receipt. That receipt means the inspection is over and you're done. You still may get a 483 from that, but that tells you that everything is finished at the end. This is an example of the 482 that they'll give you at the beginning of the process. And then just here's a little map. If you're, I'm not sure exactly where everybody is located, but if you're out in the Western United States, then you have these 2 divisions. The red here is the medical device. The Denver division goes down and covers New Mexico, goes over and covers Utah, and then below you have another division for Arizona and part of basically Las Vegas. So those are the different divisions that you'll be dealing with. And with that, I will turn it over to Christy to bring us home.
Thanks, Lee. I appreciate that. Quickly moving on, let's say after the inspection, you get a 483 observation letter. I wanted to start out, we're just going to talk about what do you do in response to that letter, what are the best practices. Starting out, just wanted to quickly point out that medical devices outside of the food industry, those are the second highest areas for 483 observations from the FDA. So certainly there is a high propensity to get 483 observations if you are in the medical device industry following one of these inspections. In terms of, what does a 483, observation, letter look like? I have given an example, a redacted example of what that may look like, but it is going to go through, of course, each of the FDA's findings. They call them observations, specific to the problems that they are finding and the elements that you did not meet, and then you've got to respond to each of those. Just a general advice, I would say just treat any 483 observation with the utmost seriousness. I think some of my clients, I usually come in on the back end. They haven't gotten us involved until after they've gotten their 483 observation letter, sometimes not until they've taken their first stab at responding, and that did not go well. So if you get observations, you need to take it, incredibly seriously. I would start out by reviewing the related section of the CFR to understand the standard that the FDA is saying that you did not meet. So you understand each of the required elements in the regulations. And that will really help you to kind of, I think, hone in on what the issue is and make sure that your response is on point. If you don't have adequate, sophisticated in-house resource to try and respond, I would just say don't try. One of my clients, they thought they're a pretty small medical device company. They thought that they could handle it. They took the first stab at responding to the 483 letter. They took the first stab at revising their SOPs, but they were quite unsophisticated, these responses, and it really escalated the situation with the FDA very quickly. They were very unhappy. In the end, with that client, we actually had to, they demanded an in-person meeting in Denver. Everybody had to fly out to Denver for this meeting. And I think we ended up having about 15 different FDA individuals at that meeting trying to calm the situation down. So, get the necessary resources that you need to respond. Just recognize, all of us have to recognize our shortcomings and where we don't have those strengths. So assess that, and sometimes that includes outside legal counsel. Sometimes that includes a consultant, sometimes includes both. I know I often work with an outside consultant that goes in and is kind of an expert on revising SOPs specifically. So I'm handling the overall response to the FDA, managing, how we're presenting the information, doing the 483 responses, but then I have a consultant that goes in on the ground and sees what the processes are, what the SOPs have been. He understands exactly what's required, by the FDA, and revises these SOPs to get them, perfectly honed in, helps train staff to make sure they're following it, and that's proved very helpful as well. I would say also just use the FDA contacts as a resource. Open up the lines of communication to mitigate misunderstandings. In most of my experience with the FDA, these FDA officials, they're willing to answer questions, and if they can see that you're exerting some sincere efforts to address their concerns, they're less punitive. It just really escalates when they feel like you're not taking it seriously. Some companies don't even respond to the 483, and then things obviously go really badly from there. I'd just say avoid becoming defensive, hostile. You just want to make sure that you're being incredibly professional, accommodating, understanding. There's no need to get in arguments directly with the FDA or that investigator. Sometimes they might not have it right, but it's not worth jeopardizing that professionalism or you want the FDA to see you as being very cooperative in all senses. So if there's any argument to be had about an issue, I think it's best to let a third party like the attorney do it for you, rather than risk having them see you in a less favorable light. Generally, you need to give an initial response to the 483 within 15 days, but you can supplement that. Sometimes it takes time, of course, to implement the needed changes. Generally, in my experience, the FDA understands this, and if you're making progress, normally they'll find that acceptable, but you've just got to keep in communication and show them that you're doing what you've committed to do. So how to respond to a 483 notice. Generally, how I address this is each of the asserted deficiencies need to be addressed with specificity. Often your SOPs need to be rewritten in a manner that strictly comports. And again, I'd say this often requires outside sophisticated consultants if you don't have the expertise in-house. I would say the response needs to be, of course, highly professional. And normally I follow a format of a call and response for each deficiency, saying this is what was cited, and this is how we have rectified this area of non-compliance. And then you need to have the documentation to support the corrective action that you've taken or are taking. Normally, I'll include a cover letter that creates some sympathy for the company, but shows the company is taking this situation seriously and they're implementing the needed changes. So in general, for all my clients in situations where they're in trouble with an agency, whether that's at the federal or state level, I always try and paint a picture of the company for these agency officials that kind of humanizes the people behind this company or behind a situation. And I think it's important in every situation that you can to try and, to the best that we can, right, kind of humanize the situation and make you look as favorable as possible to the agency that we're dealing with. Oftentimes there's a back and forth on a 483 response. It's not always a one and done, right? It's nice if you can just completely handle it the first time. They get back, great, this has been handled, we're finished. But oftentimes there will be a back and forth with the FDA until they are fully assuaged and convinced that you're in full compliance. If they aren't completely assuaged, or if the company ignores them or doesn't seem to take the matter seriously, it will escalate. And that could be a public warning letter, forcing in-person meetings at the FDA offices, suspending the ability to distribute, cease and desist letters, fines and penalties. So you just don't want, obviously, any of those things to happen. So you want to take care of it, kind of nip it in the bud right from the beginning, and put all your best efforts forward on the first try. Other considerations that I found with my clients, I have a lot of clients that are contract manufacturers. So they are manufacturing for other companies. And I think it's important to consider, if you were in that situation, you're going to have underlying contracts that may require a customer to be notified of any FDA audits themselves, regardless of the findings, or if you get a 483 observation letter. And if you don't abide by that, it could cause a breach of contract claim. So if you are in that scenario as a company, you just want to be cognizant of this too, to make sure you know exactly what third-party contracts may be at issue, and quickly identify those, and then notify the parties that you're required to notify under your contractual terms, and then try and mitigate the concerns of those third parties in that situation. I have seen, and I've dealt with a few situations where third parties that you're manufacturing for, our client is manufacturing for, they end up getting contacted by the FDA as well about this, and my client, the contract manufacturer, has not proactively notified the customer, and there have been serious allegations related to that, and nearly led to litigation in one case. So make sure you think about the periphery effects of these audits. There are several great resources, and I think this slide used to have some active links, so we'll try and update that with active links. But there's some great resources that the FDA has that you can look at, make sure you're familiar with, read through things so that it can give you some good insight on your own. With that, I don't think we've got time for a live Q&A, but if you do have questions, I would encourage you to reach out directly to Brent, to Lee, or myself, and to the extent that we're able, we're happy to go ahead and get back to you with answers to your questions via email. We appreciate your time and participation on this webinar today, and I thank Lee and Brent for their expertise and participation. And with that, I hope you all have had a good lunch hour and learned at least a little bit. Thank you.